judge must be speaking to the judge with the informed participation of all parties. A guardian ad litem sends a sealed envelope to a judge, and all parties are not a matter or member of the discussion. We have a system that no longer meets the requirements as guaranteed by the New Hampshire Constitution, and that is behaving as part of a system that is supposed to be fair, impartial, and protecting the rights of our citizens. The idea of protecting children is wonderful. We cannot protect any members of society while disregarding the protection of others, or society has fundamentally failed. While the objectives are good, the execution is poor, and the fact that these people are being treated this way is injustice. I swore to uphold injustice, or to defeat injustice, to uphold the Constitution, and to make sure this government was accountable the day I took office. And it's our job to make sure that we get that accountability back in the system.
And so, to one point or another, are you talking to point D, or are you talking to point? By the way, I enjoy the.
I'm talking to point G, which is the one I'm going to propose in a moment when we get to the bottom. What's that?
Okay.
I have it written right here, though.
Yeah, I got you.
I've been patient.
We're still at D. Oh, yeah, I got you. A little more patient. We're still at C. Representative Glad.
No. No. I appreciate everything you're doing.
Okay, that's fine. That makes sense to me. Everybody follow that idea? Should say to be included in their report after the fact? Should be added to their report? Would that be a better way?
What was the?
The last line is that an accounting of the public input provided at the GAL hearings be included in their recent report. Should it say that it should be added to their report? An accounting of that should be added or included? Well, I guess the word included is fine. If everybody else has a problem with that idea, changing the word recent. Maybe I specifically should put a date in there that I'm show what date that report took place. Wouldn't that be reasonable? The 2012 report. Oh, I see.
Report they've already done.
Well, no, they did a report, but they didn't report on it. So they actually left out information. And so you might be asking them to meet again or something. But otherwise, yeah, that's a question. I didn't have that. I didn't take that to be the way to go. But any other discussion of that, whether we should do that way? This was looking for them to include the hearing information that they already did to somehow or other get it into that report and glue it back in, not leave it out like it didn't exist.
Or just leave the word recent out. So
that would do it. That would cover that point. Representative Gillette's point was, however, that his idea was that we don't want to do it in terms of this report, but we want to have it included in any future report, which might be 10 years down the road, but unfortunately, given that we don't do these that often. That's the reason I worry about doing it in the future report. So, are you want to comment? Okay. Just leave the word recent again. Okay. D. I'm sorry, Representative Hardy.
Oh, I just can observe back when we were talking about the GAL board, that the sponsor of this petition, Representative Oldingby, is also that's the House of Representatives, one member of the GAL board, which I guess was understandably a controversial point. That's
an exciting one. So D.
Not only because he's bringing this petition, which is aimed at a GAL, but also because he himself tried to apply to be a GAL and was turned down because he didn't meet the requirements that the board had set, and he went to the Supreme Court over it.
We're not going to continue this.
With the speaker.
Make a point, Representative.
Yes, I would like to make an inquiry of Representative Horgan. Was he suggesting that the House of Representatives appoint an additional cheerleader to the board of the guardians ad litem, or don't they have enough? I'm looking at the audit which says that their composition is mostly them. And they're
Exactly.
quite happy with that. And the idea of having people who are not part of the internal system, they find offensive. If you want accountability in a board, don't you need somebody who's actually not part of the system?
That's
In
what I
corporate
said before.
governance, you don't have anyone who works for your company on your board.
That's what I said before.
Representative Morgan.
This is actually a fairly, hopefully a friendly response. That's obvious, when you have only one member, the House rule says, well, I guess this would be a statutory commission, that the speaker is supposed to appoint members in proportion to the membership of the House, and we have one, as this is right, appointed member of the majority. So he chose a fairly controversial member of the majority, but actually it's good to have a variety of views on the GAL board or any other committee. But if we did have multiple members, then the speaker and the Senate, although I understand it's hard to get people even to fill all the slots we have now, but we would be able to have a wider range of opinion on the board. So the speaker could have had, if we had 4 members on the board, the speaker probably would have to appoint 3 Republicans and 1 Democrat. So
I'm trying to get to point G. Anybody want to let me get to point D? Let me go to point D. To restructure the family division courts as courts of law, not courts of equity. That's a question, that's a statement, that's quite a strong change. It is somewhat similar to the previous recommendation that they hold the legislation do what? The rules of evidence, the statutory, there's 2 possibilities there. It seems like making all the rules statutory is one way to go. It seems like, is this 2 different things, or is this the same thing? I guess it is 2 different things, really, isn't it?
It's 2 different things.
Yeah, really not. Any further discussion of that point?
You might want to reference our RSA 490D.
Yes, let's do that. I wish Mr. Resort was here today, because he's my best referencer.
Reference 490D?
Yeah.
490D.
Yeah.
Family
I'll get
division
find the
court.
reference in there.
Title is Judicial Branch Family Division.
Yep. And then E is repeal Supreme Court Rule 3.9, or 3, is that supposed to be 3.9, is that 3:9?
Either way, yes.
Well, probably isn't, but one way or the other, I'll find that, I'll have to correct that. Which provides for discretionary appeals in post-divorce custody matters. That means that people can't automatically appeal.
Correct.
At the present time, they should be able to appeal.
Well, you can appeal, but the Supreme Court does not have to accept your appeal.
That was changed most recently in 1980. Before that, we had 9.
Actually, I think it was 2005 it was changed. The rule 3.9.
We've never had,
Representative Keynes?
we've never had an appellate court. So it's-
No, but with the question of discretionary, do they have the right to not
They
allow?
do, because we don't, normally you have an appellate court would be in between,
Well, I understand that, yeah.
and that court would take
Right.
all comers.
What
Because
do
we
you-
don't have an appeal.
What do you know
Supreme
about how
Court.
this is working now? It was in
Jesus.
2003 or whatever.
Jesus.
Oh, the rule 3.9?
3.9 changed from what, though? What
Before
was
that,
there
all
before?
appeals were mandatory. So if anyone
Okay.
had an appeal, it would have to
Okay,
be.
so that's what you'd be saying. If you agree to this, you'd be saying all appeals must be mandatory.
Correct.
Back again to what we had before,
Before 2005.
before 2005. And then, just make sure everybody understands this point, Representative Lumpkin.
I would agree that a mandatory acceptance by the Supreme Court for appeals would be a critical need in the state. I'm reading from the State of New Hampshire Guardian Litem Board audit dated January 2012, where it says, state regulatory programs like the Guardian Litem Board are designed to safeguard public health and welfare by protecting the public from unqualified or unscrupulous practitioners. A well-designed regulatory program can increase the likelihood that regulations will protect citizens and resources. We found significant problems with the board's handling of complaints because of its actions were inconsistent, untimely, and not in compliance with its own rules. We also found the board's handling of court-provided data on late Guardian Litem reporting, inconsistent waivers of complaint filing, lack of oversight of court-appointed special advocates in general and inconsistent handling of applications were a weakness of the board's operations, and renewal requirements required streamlining. Under the small number of complaints that were actually accepted by the board, that's 61, 37 of them were never actually brought to any completion. So we have potential for problems with guardians ad litem. If you go to a judge and say, I don't like this guardian ad litem, and he doesn't change it, and there's no guarantee of appeal, you could be stuck in a situation like Mr. Vandenberg right now, and you have no recourse.
So, yes is your answer, you agree?
Yes.
That F, good points though, I appreciate the support.
I was trying to bring in the context, which
Yeah.
is, this is not arbitrary. You know, we have decisions, from, if I may,
Yeah, but short.
very short.
My
We
stomach
have
is starting to
decisions
tell me
by guardians ad litem that could be considered arbitrary and capricious. If a guardian ad litem is actually working in an objective role, then they could be immediately replaced by another guardian ad litem who should find exactly the same findings. And if not, then the first findings probably aren't any better
You
than
get
the
all sorts of
second.
fixes. So now F, the mandatory appeals must be provided to all matters provided. Mandatory appeals, that is the same thing.
Imagine being your father.
Oh, in all matters that, now these, if we took away 3.9, that would happen anyway, wouldn't it?
Yes,
So,
that's correct.
so maybe we could just say instead of and that, so that.
Yes.
Okay. So that. All right. Okay, let's go to G then. What is your point on G, Representative? If you don't mind redoing it and doing it within 4 minutes.